My second question is whether FinCEN expects users of Bitcoin or other virtual currencies to register as money services businesses. And what we do know, at least from some of the comments and guidance, is that FinCEN does not intend to regulate users who are using a virtual currency to buy or sell goods and services. Sorry?
Personal services.
Or personal services. But there's an open question, I think, about whether FinCEN intended to pick up transactions that were really intended to be payment transactions for purchases for investment purposes, right? If there isn't a sale of goods or services in this transaction, then the users themselves will have a clear exemption. And how would you administer that? There's an open question. I mean, how will all of the millions of users of Bitcoin register? You can't expect them to register or to comply with the money services businesses laws. Third comment or question is that money transmission starts at $1. So many of us have gotten used to the rules in the prepaid access world. So there's another category of money services business called either a provider or a seller of prepaid access. And there are certain thresholds or de minimis amounts, such as $1,000, $2,000, under which the participants may not need to comply with the laws. But when the money transmitter, if the money transmitter regime applies to virtual currencies, which I think the answer is it does, then you have to comply at the first dollar. So it's not just large dollar amounts, it's any dollar. My fourth comment is that this is criminal. And I think that's why many of you are probably here, that you realize that these laws, both the federal money service business laws and the Bank Secrecy Act that Clair was describing, and the state money transmitter laws that Clair was describing, have civil penalties, criminal liability attached to them. And so if you get it wrong, stakes are very high, and it's critical to figure out what your model is and make sure that you have your ducks in a row, which I think leads to my last comment, which is to submit your questions and to submit your questions in writing. So if you're wrestling with the guidance or the rules and the laws and you don't know how they apply to your exact scenario, then put it in writing and send it to FinCEN. I talked to one of the FinCEN representatives who said that receiving requests, lots of requests for administrative rulings, would indicate to FinCEN that there is some broader industry outreach that is needed. And if everyone thinks they understand the rules, then great. If you're all puzzling through them and how they apply to fact patterns, send them in. Because if you send them in, then I think FinCEN has at least indicated that they're willing to try to figure out, what the right answer is for these facts and those laws. Should I stop there? Do you want me to talk about some of the definitions? Or will we get another round and come back on definitions? Okay, all right. We'll come back.
So, Brian?
Yeah.
So, money transmitter rules.
Yeah. How many people, sorry, my voice is really hard. How many people know the difference? I mean, when we're talking about money service businesses and money transmitters, do you feel like everybody understands the distinction?
No.
Okay. Yeah. Okay. Well, let's step back here. Money service businesses. Let's use the terminology money service businesses for now. Money transmission being a specific subset that we're concerned about, and that word is used at both the federal and state level. And unfortunately, so the federal and state level, the federal government's worried about money transmission primarily right now, at least until the CFPB acts more, about money laundering, anti-money laundering, and terrorism financing. So that's really, large part. Feel free to chime in if anybody disagrees with me, but that's really what the federal regime, when we talking about FinCEN, that's what we're primarily concerned with. On the state side, we're primarily concerned with consumer protection. And that's why I said until the CFPB acts, because that's what the CFPB stands for, Consumer Financial Protection Bureau. And that's a federal agency that will probably act in a way that affects the Bitcoin stuff. So just to be clear, the money transmission, I mean, I think we'll probably use them back and forth. But money transmission is actually usually the word that is used specifically for where we now fall, where the Bitcoin community now falls in the non-bank regulatory space. So I guess I'll ask another question. See, I guess I can't phrase this in a way that I can get the response I want. So, like I said, federal level, they're primarily concerned about terrorism financing and money laundering. So that sort of implicates the privacy concept that's so important, or I guess we would say, yeah, privacy, not anonymity. And then at the state level, the consumer protection implication for Bitcoin, the problem is finality. I know that's to the point, but finality is a hard thing to sell from a consumer protection standpoint, because with credit cards you have chargebacks, and so that's a tough pill to swallow. So at the state level, that's the battle we have to fight at the state level. I don't know. I think it seems like it's a little bit hard to talk about individual states and the money transfer regulations. I can say that I've yet, and Dax, feel free, anybody else who knows, feel free, I've yet to find a state that is less restrictive, that is more lenient, their definition is more lenient in practical and application than the federal government. So I think if I was, when I look at a money transmission problem, and I look first at the federal level to see whether registration would be required. When I determine that yes, it falls within a specific regime, I start from a position, this is unfortunate, but I start from a position of assuming that the state's money transmission laws apply in each individual state. And then you can come at it like regulators do, frankly, which is, prove it, that you don't. You're trying to prove it negative, but that's how I look at these issues. That answering most of the question.
Hey, Brian, you guys can chime in. Brian, can you tell folks what the difference between the federal and the state in terms of actual registrations or licensing requirements and costs and timing?
Yeah, I mean, at the federal level, I won't say it's completely ministerial or sort of perfunctory process, but it's a registration. And again, I mean, the purpose is to trigger these regulatory obligations, ongoing, compliance obligations. Less the weight isn't on the ongoing financial health of the company and ongoing compliance, except for with respect to the ongoing identity reporting, essentially. Whereas at the state level, it's actually an application, and it's a big application, and it takes a long time, and it's in I think all states, you don't automatically get approved, and there's the